Good morning, everybody. We'd like to start the second session of the National Indigenous Justice Summit. And so excited that you're spending time with us today and listening to the issues and asking questions. So this second panel, we have a keynote speaker, and it's the Honorable Steven Point, and we're very honored and privileged to have him with us. I don't think he needs an introduction, but you know, Steven's done it all. He's been the chief in his community, grand chief. He's been a lawyer, he's been a judge. Now he's the Chancellor of UBC and probably other appointments that I won't go into a lot of detail on, but his experiences are immense. Oh yeah, he was Lieutenant Governor of BC. And so he's had lots of international meetings with leaders from around the world. So very privileged to have Steven. And so Steven, the floor is yours.
Okay, thank you. And thank you for inviting me to participate in this important summit. The question of whether or not there is systemic racism in Canadian policing institutions has already been answered by the Canadian courts. The answer is yes. So why does this same question keep coming up? Why are we not asking how to change the system instead of asking again and again if racism is a systemic problem? The answer is that perhaps no one has yet set down in words what is understood to be systemic racism. This short paper is my attempt at a definition. We are not here for any other reason than to learn lessons. That is what I thought up until now. I now believe that we're also here to be tested. Life is a series of events, happenings, activities, all offering us the opportunity to learn something about ourselves. Then from time to time, we have to make a choice. Like in a card game of poker, we have to decide what cards to keep and what to throw away. We cannot blame the dealer or the other players or fate if we keep the wrong cards. We simply accept what the result is and move on. In other words, we cannot stand on the proverbial fence. We must from time to time take a stand on important issues. Addressing the Canadian justice system's systemic racism is just such an issue for our collective attention. Pop culture makes too much of romantic encounters. It's like we must find our soulmate or fail in life. It's as if someone has set us all up for failure in our life because after the wedding, we discover who we really are connected with. We are connected with someone we don't understand and someone who already has built-in issues and problems. The lesson isn't about marrying the wrong person. It's about how we adapt to make the situation work, to make it fun, and to make it happy. If we continue to look for the dream, it's a never-ending search for something that doesn't exist, except in the movies. Pop culture has created for us some mythology regarding life generally, and marriage specifically. That ought to be challenged. It makes me think about how pop culture sets us up for failure in other situations, like in poor countries and poor undeveloped places, where the outside world is nothing like what is portrayed in pop television. This culture gap is what, in my view, sets up young people to want the American dream, the good life, the life of luxury, fast food, and fast love. But when they leave the living room, TV set, or the movie theater, life is drab, undesirable, colorless, and unappealing. Life becomes boring and dead, is without excitement. Young people once told me that when they graduate, they will leave Hawaii. They called it the Rock. What must young people think in places like Nunavut? One can only wonder at the high youth suicide rate and the abuse of drugs and alcohol and gasoline. These things fill in this culture gap, gets them high for a short time to dream of the good life, believing in mythology. Can be dangerous. But pop culture continues to feed our youth in mythology, and they believe it at some level. It is odd to see someone doing the same thing over and over again and getting the same unwanted result and expecting things to improve. For example, the education system imported to the North with its built-in European values, history, and expectations. The education system is designed to get the student prepared to become a productive member of the European world. It's an extension of the Canadian objective to assimilate the Inuit. I watched a movie recently about how a young European teacher arrives in the North to teach and how the Inuit students hated coming to class. He began to see positive changes in the students once he got a lacrosse team started. The boys and girls began to play lacrosse and they gained valuable life experiences, but so did the young teacher. He learned as much about himself as he learned about the Inuit. In the same movie, the elders lived in a tent outside the community. They lived off the land and would have been called homeless if they lived in Vancouver. But in the North, they were valued very differently. They were respected elders who are listened to, who give sound advice, who are the example to follow. The Europeans have created mythology called poverty, and it means that someone has a very low income. Yet before they arrived in the New World, the Indigenous people lived in perfectly good homes that were adapted to weather conditions, and they made a living off the lands. But in the European sensibility, their housing and lifestyle was primitive. In other words, different from the European home and agrarian lifestyle. So the Indians were called poor. To the Indians, poor was someone who had poor parents, meaning parents who did not teach their children right in the sense of Indigenous values like humility, love of the land, respect of the elders, kindness, honesty, and hard working. Indians thought of Europeans as unclean because they did not bath every day, as was the practice of the Indians. Europeans were afraid to expose themselves to the elements too often for fear of getting a cold or a virus. They had experienced large-scale pandemics, which the Indians at that time had yet to experience. One society's judgments about the other are quite often mistaken. We truly need to unlearn what we have learned about each other. I was attracted to my wife when we first met because she was famous in our culture. She and I talked into the night about many things. We were compatible, yet once married, I'm sure she saw my faults because I saw hers. We've now been married for almost 50 years, and I'm still learning things about her. I love her so much now. I only fear that she will someday give up on me and move on to a less taxing partner. In the old days, prior to European contact, young people would have been introduced to their prospective marriage partners. They had little choice in the matter, but today the youth find their own partners, falling in love and living together for a time, then getting married. I don't think that we should give up on our dreams of a perfect spouse, the fairy tale magic moment of falling in love, but we do need to balance that with what is actually before us, on our path, right in front of us. Stop looking for the perfection that is too often the movie plot / dream of someone else and start making our own life work. Put some effort into your marriage and your career. Stop dreaming that one day you will win the lottery or that you will inherit a fortune from someone, from some lost relative. Give your life the best you can, and you will get the best in return. We truly live in a circle, and what we put into the circle is what we get back. If you put in hatred, greed, and envy, that is what you will get back, but in greater dimensions and weight. If you put in kindness, knowledge, and forgiveness in the circle, you will get back wisdom, good health, and happiness. The education system in the North should be teaching the students to be productive members of the Inuit people living on the land. They do not need more social workers or counselors or bank managers. They need to learn what their ancestors have to teach them about their trap lines, about the ice, about their history and legends. The Inuit are a society that can teach the rest of Canada much about child rearing, about living in a conflict-free collective, about justice and fairness from a tribal perspective. Much of the Canadian legal justice system, from the rules of evidence to bail hearings to legal common law tests, all turn on this mysterious person called the reasonable man. What would a reasonable man do is the answer to many legal questions. It even appears in many of our Canadian statute law. Who is this reasonable man? He's an elderly male European landowner who reads the Bible, who has a family, who works hard for a living, who lives by John Wayne's fighting rules, who sees the world through the eyes of Will Rogers. He's a good Englishman. He's not an Aboriginal man for sure. He has never lived on an Indian reserve or gone to residential school or fished on a river with a net while hiding from police. He has never tasted raw fish or done the round dance at a powwow. He has never attended the pipe ceremony at daybreak, nor has he ever killed a deer on the mountain as a test of his adulthood. This is the built-in systemic racism that exists in the Canadian legal system that assumes it is the best, most civilized system in the world. As Indians, we often worry about cultural appropriation, that is, some non-Indian making money from Indian designs or culture. Totem poles, for example, are sometimes carved by European folk artists who is just copying the style for something to do. The real cultural appropriation problem is that generally Europeans, that is police, judges, teachers, corporate people, all believe that they brought civilization, modernism, industrial revolution, democracy, to name a few, with them from Europe. And therefore they brought it, and it belongs to them, that they ought to be credited for bringing these things and sharing them with the Indian. After all, the Indian should be grateful for the Europeans sharing these aspects of an advanced society, sharing with uneducated, lower class, poor, drunken Indians should be something to be grateful for and not resented. The cultural assumption is the opposite of cultural appropriation. There isn't even a word for it, so let's call it what it is, a superiority complex. It is written in the hard drive, the subconscious of the European collective. It's as if the Indians have appropriated all that the Europeans have brought from the old world and now reaping the benefits of this cultural appropriation while being ungrateful, resentful, and angry at the Europeans that through their misguided kindness did commit cultural, at times physical genocide of the Indians, but that these benefits far outweigh any of these negative aspects of alcoholism, land grabbing, forced assimilation, forced isolation on the reserves, and legal discrimination through the Indian Act. This is disillusional thinking that, in my view, needs to be corrected by professional help in the collective subconscious of the European tribe. This national story of Canada needs to be rewritten. It amounts to historical mythology created by the dominant social group and force-fed to the minorities in the education system. For example, when a police officer sees another European person committing a crime, he's seen as someone from his own group, as a fellow European who is tax-paying citizen.
Just a moment. How can I help?
Tax-paying citizen that has made a mistake and needs to be reined in, all right, but respectfully. A large part of the mythology regarding Indigenous people is that they are living off the avails of taxpayer funds and that they have no contribution in the form of taxation. This mythology has never been challenged and corrected. It is reported, for example, that officers in the United States arresting a young European man after he had entered a school shooting to death several innocent children. You see the police escorting him to the police car and even purchasing a hamburger for the young man before bringing him to the police station. On the other hand, in Canada, an Indian is stopped for outdated license plates tags and is tackled to the ground, beaten, handcuffed, and taken away to the police car. We have Also seen recently in the news, an Indian man beaten by police after taking part in an anti-racism protest. So when a European police officer, burdened as he is with a European superiority complex, sees an Indian doing something that looks illegal, he sees a person outside of his own group, a person who does not pay taxes, someone who's inferior and someone deserving of police intervention. He sees an opportunity to exhibit his training, to test his police swag, his loud voice, and his police uniform. He beats the Indian into submission instead of trying to talk him down. The officer has discretion to behave in a reasonable manner or not. If it's an Indian, he chooses his path that really fits with his idea of who he is dealing with and who he thinks he is as a police officer. This is systemic racism. This is happening in the education system and the legal system. It isn't enough just to add more brown faces called indigenization or affirmative action. This only complicates matters and makes things worse. Now, instead of a European in uniform, we have our own brothers and sisters in a uniform policing Indians with the European stick. I watched an American police movie recently where this issue was front and center. The movie portrayed a Black uniformed woman confronting the reality that she was now a police officer policing her own community. Her partner, another Black man, teaches her the ropes. He explains to her the path to being a good policeman. He said, "You are no longer one of them," meaning the Black police people. He said, "You are one of us," meaning the European police force. European officers are not put to this dilemma because they're using the European police system, which belongs to them. This issue only arises because the Black woman is now a member of the European police force. The European officer is not confronted with this same choice. He does not have to choose whether he's a European or whether he's a police officer. This is the built-in racism in the United States and in Canada. In conclusion, I believe that as Canadians, we are all now faced with a choice: to ignore what is going on in Canada with regards to institutional racism, or to stand up, to take a stand on this issue. We cannot proceed further on the world stage calling ourselves an advanced democratic society if we choose to ignore the obvious truth that systemic racism plagues our justice system. This is the test I spoke of earlier. We are here to learn lessons, and we will be tested from time to time. It's time that we have racism in our justice and education system. It's not that we have racism in our justice and education system. The question is, what are we prepared to do about it? We as Canadians are put to the test with regards to the treatment of minorities by police. It is time for a national review of policing specifically. What a recent study did regarding missing and murdered women by Judge Bennett is that Indigenous women are being killed by other Canadians on a level that amounts to genocide. The police need to make changes in regard to training and the use of force. Cameras are a part of the modern world, and future abuses of police authority will continue to be documented. We cannot afford to wait until the social fabric of Canada is being literally torn apart, as is happening below the border. The federal government must take the next step to point someone to examine how police utilize tear gas and handheld shock devices and batons. There ought to be civilian oversight into situations that come to light where it is evident that police have overstepped their authority with regard to the use of force. The police ought to be required to complete training with regard to the history of minorities in Canada, specifically the Aboriginal people. Canadian Indigenous people must be given a forum in which to tell their stories about police treatment and abuses. Our Canada is broken and needs time to heal and regenerate a common feeling of trust and admiration for Canadian policemen and policewomen. We need to create a new social contract between the Indigenous peoples and the culture of policing in Canada. we must bridge the obvious gap that exists between the culture of policing and the Indigenous view of policing. Thank you very much. Grand Chief Steven Point, Chilliwack, BC.
Walaliek Sakamaw, thank you very much, Honorable Steven Point, Grand Chief and new Chancellor of UBC. Those are wise and very moving and inspirational words. A couple of things I picked up on as I went to law school myself. I learned about the reasonable man test, and when you mentioned that, that kind of put a smile on my face as to, yeah, the reasonable man is not usually brown or black, you know. And there's a built-in systemic racism, you know, that you talked about that assumes that this system is the best in the world. With that in mind, I'm going to move over to our panel at this point. And again, I just wanted to point out for all our participants out there, this panel presentation is on Indigenous approaches to justice reform. And that we did this within this National Justice Summit was pulled together in a very short, quick time. And I'm very happy and very pleased to have all these wonderful folks coming here to offer their thoughts on what we can all do. So with that in mind, I am going to introduce our panel. And the first, you know, we have Aimée Craft, who's a faculty of law member at the University of Ottawa. And then we have Doug White, who's the chair of the British Columbia First Nations Justice Council. And Joseph Murdoch-Flowers, who's a former Nunavut Justice of the Peace. And all of our panelists will be touching on the point and talking about Indigenous approaches to justice reform. And I look forward to hearing from each and every single one of them. And for now, I'm going to pass it over to Aimée Craft to begin her presentation. Aimée, you are on.
Miigwech. Bonjour, Nunavut. I'm really happy to be part of this conversation today, which I think is absolutely essential. And Steven, in addition to sharing a lot of the thoughts that you've expressed, I think we share a similar breeze. I've got wind in the trees back here, and I'm in my home territory as well. And I'm at the place where the breeze comes off the lake at Saugeen, where the river opens up into the lake. And I'm really grateful to be in my home territory. I'm also reflecting on my home territory because, you know, we have the highest amount of missing and murdered Indigenous women and girls per capita within our community. And that's something that weighs on me every day. And I think about that in the context of our failures. And I say our collective failures. So I want to reflect back to a point in time when I was working at the National Inquiry, and an exercise that we did of writing a letter. And I wrote my letter to Tina Fontaine, a young woman from Saugeen who many of you are familiar with her story. But what I said to her in the letter is that I felt like I was probably one of the most capable people to make change, and yet I hadn't succeeded in time, or I hadn't succeeded at all in order to protect her. And I think that when we think about these concepts of and values of justice, we really need to probe what that means and how they butt up against other values that are reinforced through the quote-unquote justice system today. And I want to start with this idea of poverty and privilege. And I think we know from the existing reports, and I think everyone can come to the same conclusion, this issue of need for justice reform has been considered over and over again, and there are multiple recommendations that have been made multiple times. But if we take a step back and try and understand that based on all of the studies that have been done, this idea of criminalizing poverty stands out time and time again. And in many ways, I think that's tied to this, this prejudice within the justice system, where there's been a bit of a reversing of onus, and an onus that's been placed on Indigenous people to disprove their criminality. And I think that that's the point that we need to start from, is that that is a lived reality for all Indigenous people throughout Turtle Island, throughout our territories, where there's a presumption of criminalization. And it's tied in a lot of cases to this idea of poverty and wealth that's already been spoken of. And so thinking about that as our starting point, this idea of poverty and privilege, we actually have this great insight into how Indigenous legal systems are quite different from Western justice systems. So, you know, we think of our laws in not only institutional forms, but also in terms of the concepts and the foundations of law. And a lot of Western legal systems are based on two core pillars. So individualism and the protection of private property. And some might say, you know, criminal law is not just about property, but in its original foundations and in many aspects, it is about protection of private property and protection of that privilege, and enhanced by questions of poverty. So this individualism and protection of private property that's so foundational to Western systems of law comes into direct contrast with Indigenous legal systems that have very different legal foundations. So where individualism and private property butt up against our values and foundations is in the structure of relationships that underlies Indigenous legal systems, and the idea of what we call in Anishinaabe Minobimatsuwen, so this idea of collective well-being. And those are in direct, you know, I'll say contrast, but they're also in conflict when we start to think about how institutions of justice and institutions of law are then formed. And coming back to your point, Stephen, is that, you know, we're looking at concepts like the reasonable man, and you did a very good job of describing, you know, how law has conceived this reasonable man, but taking it one step further than, you know, this older white gentleman who has private property, that man, that quote unquote reasonable man, at some point in time would have been able to own us, mistreat us without consequence. And we would have been considered the property of that man. So think of the legacy of the things that, you know, we may not have pointed to directly in this conception of the reasonable man. There's also a direct impact on the Indigenous person and women in response to the idea or ideal of the reasonable man. And I think that those are the things that we really need to take seriously when we think about justice reform. It's not a reasonable man as someone who's other than us. It's actually a reasonable man that treated us unreasonably and was allowed to do so by law. So those are the kinds of framework shifts that I think need to happen if we're going to think about justice in a meaningful way in relation to Indigenous people. And I think also to just, you know, focus on how Indigenous people see justice. Well, many of our languages don't actually have a translatable term for justice. And the objectives that we have in relation to our systems of law are very different. Like I said, relationships, maintaining relationships, and living Minobimatsuwen. So, you know, where our systems of law are more focused on, I think, what are the end pieces of the traditional justice system or the Canadian justice system. Whereas we look at prevention and we look at ultimate healing or return to wellness as the key points in time that are priorities within Indigenous thought and way of life. And everything in between is a constructed system that is imposed on us that we generally don't fit into. And I'll give one example of that, you know, in terms of interaction with police. Early on in my legal career, I worked on some law enforcement review agency cases. And I went in, you know, as a young lawyer thinking, this is an opportunity to try and challenge the justice system and the treatment by police of individuals. And it is a system that should, in theory, protect the rights of individuals and the most vulnerable, but it becomes skewed by the systemic bias and racism that's built into the system in terms of the resources, in terms of the procedures, and also in terms of the presumptions of the institution itself in terms of what it is that it's supposed to do in terms of giving effect to ideals of quote unquote justice. So I know this, some of this is a little bit theoretical, and I want to take a step back in terms of the practical ideas, and some of them are illustrated in the top 10 recommendations for reform to justice in multiple justice reports that have been, thoughtfully prepared over the years. But I think that there's an imperative for action here, and it's an imperative of action that requires not moving to systems that will replicate, failing systems of justice, but thinking about the ideas of replacing elements of systems of justice with things that reflect both the foundations of Indigenous legal systems and the values that we hold as Indigenous communities. So in that, thinking about the TRC's call to action 50, which, clearly speaks to our own institutions of lawmaking, supported by the United Nations Declaration on the Rights of Indigenous People, rethinking, what are between these two bookends, this prevention and this ultimate healing, what are those systems and institutions that exist within that? And how can they be reflected not only with, the brown faces at the table, but how can they be reflective of our different sets of values, and thinking about how we achieve those two bookends of prevention and healing. So I think, this conversation is important, but our actions, as I said, are equally important. And I think that there is an imperative for all of us to work within our communities in recognizing our own jurisdiction, not only in relation to criminal justice, but also the very similar systems that are being replicated in terms of child welfare in our communities today. So I'm looking forward to the further discussion. I'm looking forward to engaging in action together. I'm out of time, but I want to say that, I'm very grateful for this whole panel, for the organizers of the summit, and I look forward to what comes next. So miigwech.
Well, Aimée, I made the mistake initially that I wasn't close enough to my microphone, so I'm making sure that I'm really close now. That Aimée has mentioned a few things, and I really, I'm going to take these to heart. One of the things is that I very well take your point, and the criminalization of poverty stands out to me. And that our Indigenous legal systems are quite different from the Western one. I never really thought about that we would have been considered the property of the but once you said that, it just for me. With that in mind, I'll give it over to our next panelist, who is Doug White. Doug is the chair of the BC First Nation, and I'm going to ask Doug to introduce himself.
Great, thank you so much, Tuma. Asiam Nasiaya, Ainta Pek Colossal Tintani Snanemo, Ainta Pek Clishan Tani Hupachasit, Ainta Pet Lam Flodashan. Good morning, good afternoon, everyone across the country. It's a great honor to be a part of this important conversation. My name is Doug White. My co-Salish name is Colossalton. My Nuu-chah-nulth name is Clishan, and my Métis name is Lam Flodashan. We're in a very important moment in our country's history with respect to these matters. And it's important for us to find opportunities to craft shared national approaches across the country with all Indigenous peoples if we're going to be able to make a real difference. In this brief presentation, I wanted to share a little bit about the important work that we've been doing at the BC First Nations Justice Council and Justice Reform in British Columbia. There's only about 10 minutes or so, but I want to begin first by recognizing and sending love and respect to the families of Colton Bushey and Chantel Moore, Brady Francis, Rodney Levi, and all of the others that, Everett Patrick, that through just this brief time that we've been in the pandemic, and then even before with Colton Bushey, raising the national profile, that this is an issue that is sharply in front of the attention of, I think, everyone in this country. So there's what those families have experienced, what those individuals have experienced, is not anything anyone should go through in a proper country, in a country that is truly bound to the rule of law, in a truly just country. We've seen our friends and our brothers and our sisters in the Black Lives Matter movement. Black Canadians and Black Americans have also been suffering similar kind of treatment from police. And we've seen the outrage that's been expressed both across the United States of America and also in Canada. Systemic racism, as Steven Point and others have pointed out, it's a simple reality of this country. It's built into the foundations of it. And we need leadership, both of governments and of the RCMP, to deeply understand that and to urgently work together with us to act to uproot that systemic racism. Time is up on these matters. I see and understand my work and our work at the Justice Council is to bring into creation a different reality for future generations, because this is simply not acceptable. The justice reform, if we can go to the next slide of this presentation, and I think that Emma is going to be controlling the slides, so we'll do our best in that regard. I'm going to cover a number of different topics. I'll share a little bit about the formation of the Justice Council and its mandate, and talk about some of the background challenges that our people face with respect to the justice system and access to justice, and then briefly talk about the MOU that we have in BC that led to the BC First Nations Justice Strategy that we just signed on March 6, 2020. So the BC First Nations Justice Council was created a number of years ago. If we go to the next slide, in 2015, to address it. It has a dual mandate from the 200 or so First Nations of British Columbia. The mandate is structured to deal with the dual issues of overrepresentation of our people in jails and of our children in care. And our work is to engage with governments to create change in the justice system. You can see there's another slide here, the map of British Columbia. It's a very large geographic space, as is much of, obviously, Canada. 200 different nations across some very urban, some very remote. They all have very different kinds of histories, different languages, different cultures, and different contexts that they exist in. So it creates a significant diversity for us to address and deal with in terms of the work that we're doing in BC. The Justice Council itself is made up of 5 different members, one appointed by the First Nations Summit, myself, another appointed by the BC Assembly of First Nations, Rosalie Yazzie, she's the vice chair, another appointed by the Union of BC Indian Chiefs, Boyd Peters, and then 2 appointments collectively by all 3 organizations, and that is Anita McPhee and Corey Wilson. So, the context that we're in is one of real crisis. And when we think about the issues and how we craft strategy, well, we know that policing is one of the issues that's really in front of everyone's mind right now. But that is one component of an overall very complex system. The crisis of overrepresentation that was recognized so long ago now, a generation ago in the early 90s, in Parliament, they were talking about the urgent issues of overrepresentation. And at that time in the mid-90s, our people represented about 10 or 11% of the jail population. And because of that reality, the federal government enacted, they amended significantly the Criminal Code of Canada in 1996. And they added, they for the first time in Canadian history, they codified sentencing principles. And as part of that work, they They put in place Section 718.2 sub E, that is the foundation of the Gladue decision from the Supreme Court of Canada in 1999. Now, that was a recognition that 10% was a serious problem back then of overrepresentation, and now, as we all know, over the past 2 decades, rather than improving the situation, the reality has become significantly worse. Over the first 10 years of the Gladue decision, went from 10 or 11% to about 18% of people incarcerated were Indigenous. And today, we heard earlier report that the number is now just over 30%. All through that time, there's been a very significant failure to implement Gladue principles, the Gladue reports in any kind of a systemic way across the country. Some jurisdictions just simply don't do that work. While we're overrepresented in jails, we're also massively underrepresented in the justice system in terms of policing, prosecution, judges, and the staff at Attorney General and in corrections. Some years ago now, in the 1970s in BC, we had established a network of Native community law offices that functioned up until 2002, when a previous provincial administration came into power, and they completely defunded the Native Community Law Office. They massively defunded legal aid in BC, the Native court workers in BC, and then they completely shut down the Native Community Law Offices. So the justice infrastructure that in part was there to support our people was removed in that time period in 2002. So it's not surprising that things have become significantly worse. The next slide, we'll see the relative change. If we can go to the next one after that as well. This slide shows simply, this is the children in care in BC, but I think it's a very similar kind of trend about incarceration rates in the country. And what it shows is that for non-Indigenous people, in this case, non-Indigenous children in British Columbia, there has been a significant decrease in the number of people, of children in care. And that's the orange line. That's non-Indigenous peoples. But you will see for Indigenous peoples, the line has stayed relatively flat over that entire time period, that almost 2 decades of time. And so what that's meant is that now Indigenous children are about 65% of the children in care in British Columbia. I know that in some provinces, the number is even worse. So as we began the work of the Justice Council to address this grim and stark reality that we face, and it's an urgent crisis, all of these different numbers represent in individuals from our families. These are all represent crises in communities and in families. And so, this cannot be allowed to be normalized. These are not normal numbers from a progressive and modern country. So in 2017, the Justice Council worked with the government of British Columbia to come to a memorandum of understanding to establish a new justice strategy for British Columbia. And up to this point, if we go to the next slide, up to this point in history, Indigenous peoples had never been a part of structuring or building or contributing to the foundation of the justice system in this country, at least in British Columbia. We had always been entirely excluded from that work. Our voices, our authority, our jurisdiction, our families, we were not part of the work of establishing the entirety of the criminal justice system of BC. And even as recently as 2012, the government of British Columbia asked a prominent lawyer in Vancouver, Jeffrey Cowper, to issue a report about modernizing the criminal justice system for the 21st century. This is work that just happened the other day, 2012, 300-page report, and there's a single paragraph in that report that says simply, with respect to Aboriginal peoples, I know that this is a major issue in the criminal justice system, but it is beyond the scope of my work and my mandate to address. So I am simply going to say nothing about it. That was it, one paragraph in a 300-page report about modernizing the criminal justice system. And that wasn't in 1962, that was in 2012. So this MOU, where both the Attorney General of Canada, the Attorney General of British Columbia, David Eby, and the Solicitor General, Mike Farnworth of British Columbia, entered into an agreement with the First Nations Justice Council to craft a new collective shared justice strategy for the future. So as we began that work, we didn't want to just simply, we said we will take 2 years to create that strategy. But while we're doing that work, we don't just want to sit around and have meetings and talk. We have to start doing things. So 2 of the immediate initiatives, if we go to the next slide, that we agreed to pursue was with respect to increasing access to GLIJA reports, and also beginning the work of establishing a network of 15 Indigenous justice centers. And so we saw that these were 2 elements that we knew inevitably would be important bits of infrastructure, justice infrastructure, that could start to make a real difference in the lives of Indigenous peoples. And so with respect to GLIJA, we're able to secure government funding for the first time to be able to increase the number of GLIJA reports from around 75 per year up to over 300 per year, which is still not meeting the need, but is a significant increase. And then on the part of the justice centers, this is a program that is intended to provide powerful legal services that are working with the regional Indigenous peoples in criminal, family, and child protection matters, that we're finding a way to provide wraparound services for individuals that are come up against the criminal justice system and other justice systems, to provide services to them that they need. So we've got the first ones running in Prince Rupert, Prince George, and Merritt. As we got to the justice strategy, if we go 2 slides forward, there was an important meeting that we had, I think it was November 5th, 2018, where we were talking about the basic parameters of the justice strategy with the provincial government, the 2 ministers, and trying to figure out what the main key points and elements would be. And as I said earlier, we're obviously in a very defining moment because of the work of the Truth and Reconciliation Commission, because of the work of the Murdered and Missing Indigenous Women and Girls Inquiry, because of commitments to the UN Declaration on the Rights of Indigenous Peoples, because of governments saying we are now going to be shifting out of a pattern and a mode of denial of rights to one of firmly recognizing and implementing rights. One of the things we talked about was what does that mean in respect to the justice system and justice as an issue between us. And there was a book that I brought to this meeting. I'll show you. It's this book here, if you can see it, Tribal Criminal Law and Procedure. I held this book up, and at the BC legislature that day, we were meeting in a room where you could look out the window and you could see across the Juan de Fuca Strait to the United States of America. And the Coast Salish world that Steven Point and I are from, our world is chopped in half by the international border, like many of our peoples. So the southern part of the Coast Salish world is in the United States, and the northern half is in Canada. And what I said to them was, I said, this is a textbook about criminal law and procedure of Indigenous peoples just right over there. You look across that water to that land, and there are fully functioning systems of tribal law where there's tribal courts with tribal judges, and they're working to apply tribal law. And this is not particularly controversial, and it's been happening for a number of years. But that just simply isn't the case in the northern side of the border. So in this work now, today, if we're being serious about this moment that we're in together, and about being fully committed to the idea of implementing the inherent right of self-determination, then with respect to justice, we have to address that. We have to create that space as part of this strategy. And so the strategy has 2 main pathways to it. And the first path It's about doing reforming the current justice system, doing everything that we can to stop the harm and to reorient the justice system to one that is more respectful of our people. And then on the second path, it's about the restoration of First Nations legal traditions and structures, the Indigenous legal orders and traditions of our people, which is longer term work, and it's work for individual nations to do. It's not the Justice Council's work, but we're creating the space and the opportunity for that kind of work to take place. If we go to the next slide, I want to share another important, one of the very first strategies and principles, the core principle of our strategy is getting in place a presumption of diversion throughout the existing justice system. We're looking for levers to reorient and change a very complex system. When we, criminal justice system, that phrase is probably one of the most gross oversimplifications of complexity that exists. And one of the things that we've learned in our work, and certainly one of the questions that has animated the way that I always approach this work, is asking why, when Parliament and the Supreme Court has been so clear with respect to gladue and sentencing, why has it not been effectively implemented? Why is there an ad hoc approach across the country where there's no national systemic approach to implementing that jurisprudence? And part of the answer is about just the simple complexity of the overall criminal justice system, that it is made up of so many different constituent elements and actors, from policing to prosecution to the judiciary to corrections, to all of those different elements that are all guided by different bodies of law and regulation, policy, practice, all have different histories. In that complexity, we need to find overarching principles and ideas that can have effect across all of those systems. So the presumption of diversion is one of those, where from the moment that police are first engaged to the time in which an individual may be in the correction system after sentencing, that a presumption of diversion plays out. So that's an important value that we're looking to try to upend the existing culture of the status quo, that instead of the very first moment of a police interacting, or the whole system, the whole systemic racism where Indigenous peoples are seen as dangerous or criminal or inherently criminal, or the entire history of the development of Canadian law from White and Bob to today. And today's the 57th anniversary of White and Bob standing up in court in July 8th, 1963, and they said, "Our answer to your charge of hunting for deer out of season is that we have a treaty of peace between us that allows us to hunt in accordance with our own traditions." That's that's a very sort of that basic notion of pushing back and on that kind of application of law, and that attempt to criminalize the simple fact that we're Indigenous peoples, that we're living our lives as Indigenous peoples, and that in itself is a criminal act. Many of the decisions in Canadian law, from White and Bob to Sparrow to Gladstone to all of these are all quasi-criminal charges from statutory offenses for hunting and fishing, for being Aboriginal, looking to feed our family, for gosh sakes. So very if we go to the next one, well, let's skip that. Let's skip the next two that talk about justice centers. And I just want to talk just about this. In our strategy number 22, we have to establish new models of structured relations between First Nations, the RCMP, and other police forces that support new strategic and policy level, as well as community level and cooperative change, while supporting greater community level police forces. I
love to hear this and everything, and great. I'm also the watcher of time. 2.5 minutes.
Yeah, this is like my last slide. I'm just finishing. Thanks, Tuma. So this issue with respect to policing within the strategy is formulated, the way that we're approaching it is effectively this. policing has never belonged to Indigenous peoples, the system that's been created in Canada. As we all know, it's almost trite to say, policing was created to control us and to dispossess us of our territories across the country. Right? The Northwest Mounted Police were established for the purpose of clearing Aboriginal peoples out of the way for Western expansion of Canada. That's the foundation of policing in this country. We have never been a part of, what we don't need a better protocol with police. That's not going to achieve the kind of change that is required. What we need is to fundamentally re-mandate policing in this country in a way that policing belongs to us as Indigenous peoples. And we have to do two things. One, we've got to deal with the RCMP and the other police forces that, in my view, when people, when they're sent on a wellness check, and in that wellness check, instead of caring for and looking after our people end up killed by them. In my view, they have fundamentally failed in the trust that has been provided to them by the people of this country to look after and protect the people of this country. It's a fundamental breach and a failure of that trust. Every scrap of authority that police have and exercise, the enormous amount of discretion that they exercise every day, does not belong to them. It belongs to all of us. And if they have failed in living up to that great trust and responsibility, then we need to have a serious conversation in this country where, for the first time, Indigenous peoples are in a position of not just having a better protocol or better communications with the police, but where we are actually the ones that are in control, in concert with the federal government and provincial governments and municipal governments. And at the same time, do what others have been talking about today already, which is to seriously consider and look at Indigenous policing itself. But that's the work that we have right now. It isn't to sort of, tinker around the edges. We're at a moment where there's a requirement for a fundamental rebuilding of a foundation for policing in this country. So really want to thank everyone very much for the time and the opportunity to share a few thoughts in this important discussion.
Well, Doug, and I'm not going to take too much time on this, but one of the things one of the points that you mentioned, the 2 points, restoration of First Nations legal traditions and structures. That's a long-term work for all of us, and many of us have started working on that, and we're never going to let it go. And I also mentioned something previously about when you showed the stats on child welfare and criminal. I think it was our previous panelist, Scott, who was the former president of the Indigenous Bar. But I'm going to attribute the quote or the saying to the Indigenous Bar Association. That would be child welfare eventually becomes the criminal system. With that, I'm going to pass it over to Joseph. Joseph, if you would like to introduce yourself, thank you very much.
Thank you, Tuma. So I'd like to begin by acknowledging the families of Colton Bushi, Chantal Moore, Brady Francis, and Rodney Levi, who spoke or were represented last night in the conference and shared a bit about their continued fight for justice. I'd also like to acknowledge the families of others who have been lost. Tina Fontaine, Regis Korchinski-Paquette, Ijaz Chowdhury, Sami Yatim, Freddie Villanueva, Deandra Campbell, Aisha Hudson, Jason Collins, Stuart Kevin Andrews, Jamal Francique. And since I'm in Nunavut, I will also acknowledge some who we've lost here. Solomon Uyarasuk, who died in Igloolik in 2012 in RCMP cells. Abraham Natanai, Clyde River, 2012, killed by police. Kunuk Kamanik, killed by police in Pond Inlet in 2017. Felix Takaulak, Igloolik, 2012. Paul Kayukyuk, Baker Lake, 2012. Charles Kuknyuk, Joe Haven, 2016. Adlapudlat, Kingite, 2016. I acknowledge the pain that you carry in the loss of your loved ones. I acknowledge your strength in fighting for justice, and I thank you for your fight. I'm Joseph Murdoch-Flowers. I'm a legally trained Inuk in Iqaluit, Nunavut. Inuk is the singular form for Inuit. Iqaluit is the capital of Canada's largest territory, Nunavut. Nunavut comprises 1/5 of Canada's landmass. Nunavut is also the newest territory carved out from the NWT in 1999 after the signing of the Nunavut Agreement on July 9, 1993, 27 years ago tomorrow. I'm not originally from Iqaluit. Rather, I was born in Nunatsiavut, which is the Inuit territory in Labrador, in the province of Newfoundland and Labrador. And I was raised in Nunatsiavut, or in Happy Valley Goose Bay, Labrador, and in Nunavik, Kuujjuaq, the Arctic region of Quebec. I studied law at McGill University and began my legal career in Iqaluit 7 years ago as a defense lawyer. I worked with the National Inquiry into MMIWG, and then for a brief time I worked in suicide prevention. And until about 2 weeks ago, I served as a Justice of the Peace for Nunavut. So right now I'm in between things. I will soon be starting a new project, but I can't speak publicly about it just yet. As a Justice of the Peace, I presided over court in many ways similar to a provincial or a territorial court judge. I heard bail hearings, guilty pleas, trials, sentencing, peace bond applications, child apprehension hearings, and municipal court. And today I'm going to focus my comments mostly on the administration of justice and in particular on Gladue. But I will briefly comment on the issue of policing as a person who lives in a community that is dealing with standoffs on a nearly monthly basis. Regularly we hear on the news that we need to avoid certain areas of town because of an ongoing standoff. Police cordon off the area, negotiate with the person inside, and more often than not, the person emerges alive. Well, any shootings by police is a shooting too many. We have to recognize that for the most part, police manage to de-escalate very volatile and dangerous situations. These situations are dangerous for the person in distress, the family that is in the home with the person who's in distress, for the police, and for others in the immediate area. It is important to recognize that there are police forces with the training and skills necessary to de-escalate these very dangerous and volatile situations. That's not to say that, well, it is worthwhile to ask questions around the appropriateness of police responding to situations of mental distress. We have to strategically examine the realistic reallocation of resources for crisis response. We demand that police act in too many roles: social workers, crisis negotiators, ersatz coroners, and more, including police work. And if you spread the resources too thinly, you're going to end up with an inferior service. And that's not fair to anyone. We also must be critical of the bad apples argument that some police officers are bad apples. Chris Rock pointed out how this argument fails when you apply it to pilots. Most of our pilots like to land, just a few bad apples like to crash into mountains. We wouldn't tolerate bad apple pilots. And so we have to draw a bright line of our intolerance for armed and dangerous bad apple police officers. Some jobs cannot have bad apples. I'll now talk a little bit about Gladue and 718.2E. 718.2E and Gladue are largely failed tools. The Supreme Court has admitted it in IPLE in paragraph 62. They're largely failed projects because they focus on individuals in the context of historic ongoing trauma from systemic racism and discrimination that affect the individual, their family, their community, their nation, and their country. In my experience, when these tools are deployed in court, they focus on the individual who's in court while ignoring the victim, the community, and the broader social context in which the person has lived and will continue to live. That's counter to what the Supreme Court said in Gladue. They said that we have to account for the person's circumstances, which would also take into account those other things I've spoken about. But the reality is, we talk about the individual circumstances without connecting that individual to whatever resources are available in the community as alternatives to imprisonment. Gladue is an individualistic, liberal approach to a collective problem. Applying Gladue in this way is like replanting a seedling in a toxic swamp of anti-seedling hatred with nutrient insecurity and poisonous water in historically inferior soil alongside other damaged seedlings. What do you expect if you don't address the growing conditions of the seedling? This is why Gladue will fail. We need instead Pirukvik, a place to grow. That being said, I disagree that deeply engaging with Gladue and written decisions is necessary, as suggested in point 9 of the immediate action points. In some areas, it might be useful to promote this idea, I mean some areas of Canada, but not in Nunavut. My disagreement, I think, speaks to the diversity of courts across Canada and the diversity of the realities that judges live in across Canada, as well as the diversity of the backgrounds of judges. Now, more diversity is needed, of course, but there is diversity on the bench. Nunavut is 85% Inuit. The judges here have lived here for a long time. They have hunted, camped, and fished with Inuit. They have raised their children here. They have laughed and cried with Inuit. They have represented Inuit and prosecuted them too. They have worked closely with community groups to design healing and wellness programming here in the territory. And while the judges here are not Inuit themselves, they are situated in Inuit communities and thus have a greater understanding of the realities of living and working in Inuit communities. The discussion point goes on to suggest that we need to have comprehensive and in-depth engagement by way of written judgments for sentencing and apprehension matters. If we require all judges in Nunavut to write decisions for every child apprehension or sentencing matter involving Inuit, then we will run into a Jordan problem, the delay, with significant backlogs from those written decisions. In normal times, not COVID times, this court in Nunavut sits in Iqaluit and at least one of Nunavut's 24 other communities on nearly a weekly basis. And when the judges go out to the communities, they preside over trials, guilty pleas, and sentencing hearings. So if you're not satisfied with the judge's decision and the judge's engagement with Gladue, appeal, appeal, appeal. That's what it's for. Like any other player in the justice system, judges build a public personality through their judgments. Some judges are extremely well versed in Gladue and know a great deal about the communities in which they serve. To then suggest that a judge needs to write a decision explaining all of that over and over and over again is not realistic for all communities in Canada. There's a danger in thinking that what works in one community in one court will work in another community and another court, and that's an ongoing theme of what we've been hearing about today. So maybe my comments on Gladue are a little bit confused, but maybe it's because I'm confused about Gladue. How do we engage with Gladue in a meaningful way? I'd encourage you to read the decision of Jomi, 2013, NUCJ 19, in which then Senior Justice Robert Kilpatrick sentenced Mr. Jomi, who was suspected of living with FASD. Justice Kilpatrick, following the Supreme Court's guidance in Gladue at paragraph 84, perhaps, to have witnesses come in and give evidence about what resources are available, called in some witnesses from the government of Nunavut to provide evidence on the diagnostics and the treatment of FASD in the territory. Finding very little useful, very little in the way of useful evidence for diagnostics and treatment on that issue, Justice Kilpatrick put it on the defense to advocate for Gladue-like services for the accused. I would also encourage you to read Justice Cooper's decision in TQ 2016 NUCJ 04, in which the lawyers came to court with empty hands, but not for lack of trying. Without a whole of government and whole of community approach to embracing the spirit and intent of Gladue, it will continue to fail. As Justice Cooper said in TQ, I am advised that there is no treatment available. Essentially, what we have accomplished through the court process is to simply diagnose and label a problem, but nothing further. The situation is similar to having a medical doctor diagnose a broken leg, recommend a cast, and then not have the resources available to put on a cast. Further, if we're not doing Gladue properly, let's stop doing it until we can do it correctly. Gladue submissions are disrespectful and re-traumatizing. Lawyers come into court and rattle off the traumas of the person's circumstances. And when I was a defense lawyer, I was guilty of the same thing. It is too casual with highly sensitive information. Perhaps it can be submitted by way of a Gladue report in Marat 2019 ONCJ 618. Justice Band found an approach to having extremely sensitive and traumatizing information placed before the court by way of agreed statement of fact and sealed exhibits for the protection of all persons in that courtroom. We can speak of creating Indigenous courts and increasing Indigenous representation in the Canadian criminal justice system, and this is very much a worthwhile endeavor, but it cannot ignore the fact that the system that we have in place today is what we have now, and we have to live with it as it is. We can fight to change it, but we also have to live with it as it is. Revitalizing Indigenous justice is a creative endeavor and will be particular to the Indigenous peoples and territories, and it will look different from place to place. Thomas Jenkinson, also known by his musician's name as Square Pusher, has written that it is essential for any creator to want to negate and to reject, but this has to be coupled with a consummate understanding of the phenomena one seeks to reject. Otherwise, not understanding the language of negation, the object of the negating will misunderstand what is being shouted at, and it carries on regardless. Canadian criminal justice will carry on regardless of what we do, and it will continue to operate on us too, regardless of what we do. Kwenami, thank you.
Okay, Joseph. Well, Aliekti, thank you very much. Those were very good words. And as you were speaking and presenting to us another perspective of what we are all looking at and facing with when we're looking at the justice system in Canada, and in particular in the North, as Honorable Marion Buller pointed out to us this morning, there is a diversity of nations, Indigenous groups, and that we must never forget that. And that's one of the points I take from it. The other one is that, living with what we have, I remember a particular quote. I'm not so sure that I can't remember who said this to me a long time ago. But as I was embarking upon my legal career, they reminded me that the law and the justice system is a very dull knife in which we can use to hack away at societal problems or societal issues. But in many cases, it's often the only knife that people have. And thus it does a hacking job, So, and with that, I thank you again for your wise words. And I thank all the other presenters on the panel for their wise words and their lessons to me, for all of us to think about as we move ahead in building a better future for for the next generations. No. I'm going to see if Judith has any concluding remarks, and then we can open up for some questions. There are a number of questions. I'm looking at it in the chat there. I'll try to go over it, and Emma has been doing it presenting them to my attention, but I'm going to pass it over to Judith at this point.
Thank you, Tuma. Really appreciate the presentations and the thoughts. Why don't we just start with questions, and I'll just maybe say at the end a short wrap up. So I think listening to the audience's questions is really important. So.
Okay, let's go to the last, trying to get to the bottom. There's a lot here. Okay, some of the information will be presented in the various social media and websites, like the names of the cases, citations, report, PowerPoint presentations, you know, and in some ways there's, you know, here's a good one for the panel presentation. There's a question from person Shelley. He says that I represent Indigenous workers in labor and wonder what we can do there to help make change. So if any of the panel want to talk about labor, employment, and perhaps even move a little bit of the conversation to civil law, not just criminal family. So what can the individuals do to help in labor?
Hi, this is Doug White here. Tuma, so yeah, there's all different kinds of bodies of law that are playing out, and we have in our own communities, our own traditions, you know, different ways of approaching all of these different issues. And we also have, so that's like the longer term reestablishment and working to resolve disputes and issues in accordance with our own Indigenous legal orders and traditions. We have, this is a very firm commitment in the TRC about establishing institutions, Indigenous legal institutions across in the country. I think at UVic, my alma mater, where I went to law school, over the past number of years, they've established the Indigenous law degree program, and the Indigenous Legal Research Unit or Indigenous Law Research Unit. And so they've been looking into this kind of an issue to figure out what are different Indigenous approaches across the country to these different kinds of bodies of law that exist in the common law and Canadian law, but also importantly, what are the Indigenous ways of thinking about law and the different categories of law that exist and how to make use of them. Civil law is obviously one of the most important aspects. I mean, criminal law is something that we should only be engaged with from very, very rarely. But civil matters are things that come up more regularly, and we want to be able to find ways to resolve disputes in accordance with our own Snow Wyeth or teachings or laws. So the most immediate, the book that I held up, that part of the world, they also deal with civil law matters down in the States, and they've got recognized jurisdiction over those areas. And it's certainly something that we want to be able to think about and create space for. As Joseph said, I mean, this is work that will play out with respect to every individual Indigenous nation will have to figure out its approach and how it wants to either take up that space or not, and if they do, what it looks like. But I think it's a very, very important to keep in mind, this is not just about criminal matters or family law matters, it's also about civil law and about our own Indigenous ways of thinking about law. Thank you.
I think I would add to that in saying that we need to rethink, foundations of legal orders, and one of those is that distinction between the public and private. So I know Doug alluded to some of the work that's being done at ILRU and with various Indigenous scholars that are thinking about what our Indigenous legal orders look like and what our institutions of law might look like. but challenging some of those dichotomies between what is public, what is private. And, any of us who've grown up in communities and surrounded by our aunties have seen that, the private becomes public very quickly when you're thinking about the implementation of our own systems of justice. So, I think that's one note that we need to take seriously within our different community and nation contexts as we're thinking about this rebuilding exercise that Doug was just pointing to.
A lot of the questions are related to the First Nations Justice Council. There's this one, I'm trying to summarize a particular themes in there, I guess this one is, basically, it's a general one that kind of will help answer a lot of the other questions. And I'm sorry that we won't be able to get to every single one, of course. How will the justice centers be different from the previous Native community law offices that existed? And how will they be different from what court worker role is doing? Maybe that's a question for you, Doug.
Yeah, sure. Thank you, Tuma, and thank you to whoever asked the question. So, we've had different ways of seeking to support our people that are challenged by the justice system over the years that have been, So the court workers, I think, were established about 45 years ago or so. And I've been in BC, I've been the vice president, and recently I was the president for a couple of years of the Native Court Workers and Counseling Association of BC. And this is a very important institution that's done a lot of good work over the years, supporting our people in the criminal justice system. The Native community law offices were also established quite a long time ago, 1975. And this was, they had quite an expansive scope of activity where there would be lawyers that were in the Native community law offices that worked on a fairly wide range of issues, just helping people with their general legal matters, whether it's wills or doing paperwork for tax purposes, or including the things that we've been talking about today, dealing with the criminal justice system and family justice system. The Indigenous Justice Centers that we're building now, with the first three, and one's in Prince Rupert, Prince George, and Merritt, and there's a plan to have up to create 15 of them across the country. Now, because of the COVID-19, because of the pandemic we're in, the functionality of the centers was obviously impacted like every other part of the justice system. So we do have an urgent proposal to get a virtual Indigenous Justice Center up and running that would facilitate, using technology, that would facilitate both the functionality of the bricks and mortar justice centers, but also to serve other peoples across the whole province. So the Justice Center, the way that they're different, I guess here's one way to think about this. When people talk about justice reform in general, and not specifically about Indigenous peoples, one of the things that people often talk about is liberalization of justice services. And by that, what they mean is that, maybe lawyers don't always have to be the ones providing services to people in the justice system. Maybe non-lawyer actors can take on a role. And, part of one of the challenges that we have as Indigenous peoples, I think, is in some way we've been, at least in the BC context, I'm not speaking anywhere else, I don't have knowledge about other parts of the country of any depth, but in some way we've almost been over-liberalized. And that's not to say anything disrespectful about the court workers, they're doing good and important work. But when we don't have proper full access to solid legal representation and advice, it becomes a serious problem and a challenge for our people. And so we want the justice centers, they'll be staffed up with lawyers that are immediately available to Indigenous peoples the moment that issues arise. We want people to be phoning to and be engaged with them. When I was chief of my own nation and going to help members in child protection matters, you go to the family court lobby any morning, and it's always a sea of Indigenous families that are horrified. They're confused. They don't know what their rights are. They don't know exactly what's going on. They don't know how to protect themselves and advocate for their own families. And they're turning to some random duty counsel that happened to be in the building that day is the best sort of option that they have. And so they're often not getting real legal advice until this is the moment that someone hears that MCFD is investigating them. And then all of this stuff happens all along the way, and then there's like a continuing custody order hearing of some kind way down the road, and then the families may be getting legal advice of a significant kind for the first time. That lack of legal advice and legal representation, powerful advocacy of lawyers doing that work, if they're not there right at the outset, then I think it just becomes a challenge. So in our justice strategy, one of the major strategies and commitments that we have is to get in place powerful legal advocacy for our people. And that's as a complement to the court workers. And so it kind of goes beyond the scope of the Native Community Law offices, or it's not necessarily beyond the scope, but it's a very different kind of focus. And in addition to the Indigenous Justice Centers, one of the key strategies is for us to take over. So we've got the Law Society of British Columbia that provides legal aid services. They're now called Legal Aid BC. We need to and we have a strategy and commitment to take over the portion of legal aid that is delivered by that provincial institution, to take it over in the name of First Nations in the province. So we'll also be taking that on.
Okay, we have, I think we have about 3 minutes left before we have to close off here. I'm just going to ask a quick question to Aimée. There is a question from Elizabeth here. She's asking, what are the Indigenous justice systems in Canada or elsewhere? Where they implement their own Indigenous laws through courts, and who are the authors writing about this? Maybe if you can just quickly name off a few authors, and then we can have these posts, or who's working on creating Indigenous laws throughout Canada that you know of.
Yeah, so I think that's a huge question, and I'd be happy to field that even offline. There are Indigenous scholars who are doing work in a variety of universities from a variety of different nation perspectives. So, we've talked about the UVic work. We have colleagues like yourself and Naomi Metallic on the East Coast. We have, a huge cohort within Ontario at different institutions that are doing really amazing work. Too many to name. But I think that, one of the things that has been said already today is the importance of the work in community. So, whereas scholars, I think Indigenous scholars, we see ourselves as responsible to our communities and assisting our communities, the work is being done within each of those communities. So I'll just talk about very briefly some of the work that I did with Grand Council Treaty 3 within our territory. In developing maybe declarations, so work around water and looking at responsibilities to water and reinvigorating Indigenous legal systems through those mechanisms, and looking at the structure of Indigenous legal orders and the mechanisms that are attached, the procedure that's attached to substantive laws. And in thinking about that, there's also some projects out of West Coast Environmental Law, the RELAW project, and there are so many now, and it's so beautiful to see these resurgence and revitalization pieces taking place and being done differently according to different methodologies. And I guess my comment to that is, look for the ones that are being generated from communities themselves, where communities are taking this initiative to, and it's an uncomfortable question, are we revitalizing, are we resurging, are we drafting, what is it that we're doing in relation to our Indigenous legal orders, and thinking about in that, these very different ways that are responding to immediate community needs. And in some cases, it's done very informally. So I think the best way to think about it is look at your territory, what's being done within that territory, look at some of the scholarship around this issue, look at some of the community-based initiatives. And I'm happy to follow up, and we could even send something by email with a list of some readings and resources to support that.
Thank you, Aimée. And I'm going to pass this over to Judith now. Walalio.
Thank you. I just really want to thank Steven Point. I had never thought about the reasonable man as being English, but I had a great laugh, and really appreciate that you brought in all our Indigenous values and ways of being, and really gave me a lot to think about, and I thank you for that. And I'd like to thank Aimée, Doug, and Joseph for their presentations this morning, letting us know what work is being done out there and what still needs to be done. As you know, we have a huge body of work ahead of us, but it's good to know that there are processes in place that are being looked at. And I just really want to bring your attention to the action points, and in particular, number 7, where we should be creating our own Indigenous courts. And I think legal system, justice system, or restoring them, I think is more that way, because that's going to reflect and implement our laws and ways of achieving peace and justice. And just taking that back and doing it in our way. Like, this system hasn't worked for us, and we're going to have to work on a system because so many of us live away from home. And so there's two-pronged approach. One, in the community, grabbing on to self-determination and UNDRIP and our own self-governing ways, and do that. And then we need to also work on what's going on out in the world, tearing down systemic racism. And thank you for that definition, Stephen. I really appreciated it. And so really, thank you all for listening, for your questions. Got some good comments from different people. I've read them all, so thank you so much. Tuma?
And the last thing I just want to make everybody aware is that once we go on a break, there'll be another break before the next panel. There's going to be a performance by Sacred Matriarch Productions, Echo Alik, during the break. It'll begin 5 minutes after we finish here, and you just have to go to the Testify Indigenous Facebook page. There's a lot more activities going on, and I really enjoyed this today. Walalio, Walalio, taho.